Welcome to Community Cocktails with Kimberly, hosted by Kimberly Woodard, a realtor who's been selling homes in North Texas with more than 21 years of experience. Join her every first and third Wednesday of the month as she meets with top community leaders, local businesses, and real estate industry experts to help you get to know the area you want to call home. Don't just love your home, love your community. And now your host, Kimberly Woodard.
Welcome, viewers, to this episode of Community Cocktails with Kimberly. So I have a wealth of information for you guys today. I have Kayla Wood here, and she is an attorney with Allen, Texas Attorneys. Welcome.
Thanks. I'm glad to be back.
Yes. Well, we did, before we talked about kids and if you had a kid under or turning 18, you know, power of attorneys, and now we're going to be talking about deeds to real property and estate planning in Texas.
Yes, exactly. Oh, exactly. I know, it's riveting information. But actually what's really cool about the state of Texas is that we have a vehicle that a lot of other states don't have. And so we've got a means that we can leave real property to our beneficiaries and not have to have a will. So it's actually a great thing.
Another plus for why people are moving to Texas.
That's right. The great state of Texas. Yes.
So let's talk. There's all kinds of scenarios out there. We were kind of chit-chatting before cameras came on, but, you know, we see people, you know, now a lot of, you know, young professionals are going out and buying their first home.
Absolutely.
And
yes.
Maybe they don't have a significant other, and I give them a, you know, great applause for being able to, you know, do that, because real estate is the best investment. But, you know, we never want to think of the, you know, what if something happens to us
right.
scenario.
Exactly.
But it is life, and we do have to talk about it.
And it's like they always say, there's two things you can count on in life: death and taxes, right?
Yes.
So one of the things that you can do is you can estate plan. And so even like you mentioned, if you're a young adult and you're just starting out, it's important to have a plan for your estate.
Yes.
And even if you have a small estate. I think last time we were here, we talked about, I have a friend whose son owns his own lawn business. And so, you know, he needs things for, like, he needs a will because
right.
he's got all kinds of equipment for his mowing. So
right.
he's got trimmers, mowers, trailers, riding mowers, you name it. So a great thing about young people and even older people who've been married for a long time, if they own a home, how do you go about leaving it, and how do you go about estate planning?
Yes.
And so the great thing is obviously there's a will. Most people have heard about a will. You can always die intestate, meaning without a will. Or you can do something in Texas, which is great, and you can either have a survivorship agreement, which is typically between a husband and wife, or you can have what's called a transfer on death deed. And so both of those are great tools that are pretty low cost, relatively speaking, to what it costs to get a will, or relatively speaking to what it costs to actually probate. And so my goal is always to set up my client's estate so that we don't have to probate the will.
Okay. So
that being said, I'd love to draw you a little picture over here. All right. I requested the white and whiteboard so that I could draw pictures for it. For you and for your audience, just because I feel like it's so helpful to learn.
Visual aids.
So a couple of things, yes, visual aids. So a couple of things that I like to do, okay? This is what I do for all my clients, all right? There are kind of a couple of ways you can leave things to beneficiaries in the state of Texas. The first is the will, and we've all heard about this.
Yep.
You know, I'm in my right mind, I date it, I've got the capacity to execute it. But another thing that a lot of people don't know is that you can do beneficiary designations. And I'm just going to abbreviate so that I don't stand in the way of the right and right board, okay? So basically, with the beneficiary designations, these are things like your IRAs, your 401ks, and as long as you have a beneficiary listed on there, then those are going to trump the will, and they're going to transfer without having to probate.
Right.
All right? Another thing that we're here to talk about today, since you're in the real estate business, is we're going to put a little house on there. Oh, yeah. And the house can transfer in a couple of different ways, okay? So one of them that I mentioned was a transfer on death deed, and the other is a survivorship agreement.
Okay.
So let's say you and Glenn are married. Y'all been married for 20-something years now, all right? You bought your home between the husband and the wife, all right? So here's your house. And then... and because we're community property in our state, half of the house is Glenn's and half of the house is yours. Yep. Right. Yes. So what happens, I'm going to pick on Glenn only because he's not here and he's a little bit older. So, and plus, relatively speaking, statistics wise.
I like to say he's a lot older.
Oh, okay. Well, I hope he doesn't watch this. She said it, Glenn, not me. But anyway, so relatively speaking, like you can count on typically the gentleman is going to pass away first. All right. So sorry, Glenn, you're passing away first. Just in my example. But you're going to want your half of the home to transfer to you.
Right.
All right. And then same thing, if you were the one that would die first, you would want your half of the home to transfer to Glenn. Okay. So this is something that's the transfer on deed can take care of. To transfer on death deed can take care of for you.
Okay.
So what you can do is you can fill out this deed. We draft them. They're relatively inexpensive, probably around $500 or $600. And what happens is you can leave language in here. Not only that you're going to leave it to one another, but then you can also go to your kiddos as long as they're of the age of majority. And we'll kind of get into that in a little bit in a minute.
Gotcha.
But the other thing is a survivorship agreement. Okay. So let's just say that you and Glenn didn't have any kids. All right. You can then do the same thing where you just leave it between the husband and the wife. All right. So forgive my little arrows here. They're a little crooked. But anyway, so you can do the same thing. They're basically the same document. It's just that one can leave it to additional people and one can leave it to just to the husband and wife. Yeah.
And let's say why, this is better than the probate, because the probate takes a while.
It can take a while and it can be expensive, depending on what kind of probate you need.
Right.
It can cost anywhere between $3,500 and $10,000, and it can take anywhere from 3 months to a year. Some of them take longer than that if it's a contested issue. And this way, because your beneficiary designations trump the will, if you've got either one of these kind of deeds, the transfer on death deed, or we like to call them a TOD, or the survivorship agreement, then that trumps anything that's in the will. So even if people wanted to fight it, if you've got some kind of contention amongst the family, then nobody can fight it because that's going to trump.
And let's dip in. We have a lot of different scenarios with families, especially those with blended families, where one spouse moves into the other property.
Correct.
How this can be a benefit.
Yeah. Okay. So what happens is, let's say, for example, when you and Glenn got married, Glenn already owned his home. Okay. All right. Y'all were down in Dallas, down in the M Streets. And so Glenn owned the home. So y'all got married and it was his separate property. Okay. So it was his home. But let's say once you were married, he wanted to be able to do one of these kinds of deeds. Right. What he could do was he could do something which is called a special warranty deed. And that way he would give half of the home to you, and then y'all would own it as community then, and then it could go down and you could do a transfer and death deed, survivorship agreement. You could do all those. Gotcha. But that also goes into something else I know we talked about that before we were meeting today, and we were kind of going over what all we wanted to discuss. What happens if, someone wants either to own it outright or they, buy it with their separate property or something? Right. Same exact thing. So you can do it even during the community if it's got, if it's with separate funds and stuff. I mean, I guess
lots of scenarios.
There are a lot of scenarios, and that's one thing I want to talk about too. But before we started, you can't practice law in a vacuum. Each case is different. So that's why it's going to depend on when you bought the house. Was it during the marriage? Was it not? Was it bought with separate funds? Was it not? So that's why you got to go see an attorney so you can figure out the best way to do it. You might need a special warranty deed. You might not. For example, in my case, we got a better interest rate if Jeff bought the house in his name only. Right. So even though it was bought during the marriage and was bought during the community, it's half mine, but it only has his name on it. So if we wanted to do a deed like this, we would have to have him do the special warranty deed, leave it over to me, the half, and then we could go from there.
Gotcha.
Yeah.
Yeah. Because definitely there's a lot of, different scenarios, and my viewers are probably out there going, okay, well, what
yeah.
am I doing?
Yeah, wait, I owned the house, then my husband moved in, or what about you get the house in a divorce?
Yes.
And then you remarry. Same exact thing. So there's all kinds of ways to do it. But like I said, this is such a more efficient way and less costly and more timely than having to go through the whole probate process.
Definitely.
Yeah.
Definitely. And I've seen the probate process, and I can attest, I've seen anywhere from probably the shortest of 45, 60 days to, a very long process when it's, more complicated.
Right. Especially when there are a lot of properties involved. Yeah. The more properties you own, the more deeds you have to file.
Right.
And I know one thing we talked about before coming today was, let's say you own a house in Dallas and then you're moving to Plano. All right. Does the deed follow you or does it follow the house? The deed stays with the house. So if you sell the house in Dallas and you move the plan into a new house, you'd want to execute another deed. To leave it to the, to your kids, to your family, and it doesn't have to go to your kids. I've got a client who's got a son in his 20s. He bought a home and he's not married yet, even though he does have a pretty significant other. And he left it, right now, since he's not married, he wants it to go back to his parents should anything happen to him. And he's young. He doesn't need a will, and it doesn't need that expensive, yet, because he does have 401ks and IRAs where he can do the beneficiary designation. But he wanted to leave the house to his parents should anything happen to him. And that way they don't have to probate or anything. So it's so for even young kids.
So back to the point, it stays with the house. So you couldn't really do a blanket one if you own multiple properties. You need to
do one for each house.
Property.
Right. Every property has to have its own separate deed. Correct. Yes. And another thing people always ask me is, well, what if I have a mortgage on it? It's okay, because then you can have in your will, you can have some language that says, oh, well, my house gets paid off, or it goes ahead and follows the deed, and the house will get left to my people, and then my people can decide to sell it and then pay off the debt with the proceeds of the house. So even if you have a mortgage, you can absolutely do one of these types of deeds.
That makes a lot of sense. And there's so much.
I know there is a lot. I'm sorry, and that's why I draw so many pictures, because I'm trying to make it make sense.
Yes. No. And I see definitely the benefits, because it does make and it's clear, especially when you get into those scenarios where maybe we'll use a blended family is probably a good scenario where you have, and maybe one of the new spouse moves in and then something happens, and then maybe if this is already done, you don't have maybe kids fighting over.
Right, exactly. And I always like to refer to things as the Cinderella effect.
Yes.
So with Cinderella, as you know, let's say you and Glenn are married. You pass away. Glenn is left. He owns the home. And then new stepmom moves in, and she tries to say that the home is hers. Glenn passes away, and now your boys are left going, why does she get the house? So if he had one of these on file, then he could leave it to the boys, and we wouldn't have to worry about Cinderella's evil stepmom.
Yes. No,
it does happen.
It does.
It really does.
I mean, I was at the title company, and there was the title guy came in. He was like, I apologize for being so late. But she wasn't evil, but she thought the house was, hers, and she was getting the proceeds, whereas she really wasn't, and the kids were. And, he was encouraging her to sign the closing papers.
Oh,
no.
no.
She was not wanting to, but she did. But,
yeah,
I mean,
that's sad.
There's a lot of stress in that transaction.
Well, and, everybody always says, oh, my family gets along great. And you think that they do, but when money's involved, things come out. Yes, exactly. So that's why if you have one of these deeds on file, then you don't have to worry about it.
No. Yeah. I mean, I think this is definitely just something that I didn't even know, and I'm...
Well, you're going to come see me. I'll give you a good discount.
But, I mean, I'm just saying, I didn't know, because everyone just assumes, you do the will, you hear the probate, and that's kind of, what we... probably in the general public hear about. We don't hear about these, other scenarios on how important they are.
Well, and the survivorship agreement, it's been around for a number of years, but the transfer on death deed is relatively new to Texas. We've only had, 3 or 4 years. Don't quote me on that, but it's only been a few years. But now that we have it, I use it on a daily basis. I literally recommend it to all my clients. I mean, my mom really well. I'm making my mom do one. Just because this didn't really exist when she did her will after my dad died, 9 or 10 years ago. So I think it's a great thing. I literally think it's one of the best states because we offer this. A few states offer it, and I know one thing we were planning on talking about is what if I own property in California or Florida or somewhere else. I can't speak to all 50 states. I'm not licensed in them all, so I don't know exactly the law there. But what I do try to do is I do try to find out what happens. I know Colorado can do it. I've had it done in Colorado. Yep.
A lot of viewers that have Colorado
Yes,
properties.
If you've got Colorado properties. And I want to say that I had one recently in, it was either Louisiana or Kansas that did it for me. So what I do is I'll usually pick up the phone and call either a title company and I'll ask to speak to their legal department, or I'll call up I've got a few attorneys here and there that I know in other states.
Right.
And I can call them and ask them, hey, I've got a client that's got property in Colorado. What can we do? Do you have something similar to what we call the transfer on death deed? And knock on wood, I've actually been able to have some luck in finding other states that will do it for us.
Oh, wow.
Yeah. Okay. So that's because people, often have, vacation homes and stuff.
Yes,
so it can be done in some other states.
Okay.
So that's nice to know as well. Yes. But at least it's worth a shot. I mean, all it takes is a 5-minute phone call for me to call an attorney or a legal department and ask, do you offer this in your state?
But I think, emphasize the point, if you have multiple properties, you do have to have it. Just doing one is not going to cut it.
Right. It follows the property, not the person. Yep.
Correct.
Yes. And especially if I've got one client, for example, the wife owns a couple of rental properties that she owned before they got married, and then they own a house together, and they own another property that they bought during the community, just as kind of land that they want to develop one day. So they've got 4 properties that I'm doing deeds for them with right now, just because the wife's got the 2 that are down, in Dallas that are rentals. And so we're going to do some special warranty deeds so that she and her husband can own them together. Yeah. And then we're going to do, after we own them together, then we're going to do the transfer on death deed. So it's kind of a 2-step process if only one of a husband and one of a wife is on there. But it can absolutely be done.
So since it does follow property, I know this may be a question that some viewers are maybe thinking, and they're going to the closing table to buy their new home. Can this be something that we can add to be done at closing? Or do we need to wait?
I don't know about that.
Okay.
I think you might need to wait. And here's the reason, just off the top of my head, why I think you need to wait. The public records, and I'm not meaning to pick on, the county clerks or anything.
It does take a while.
It does take a little while for, the closing documents to happen. So you've got to get the property in your name first.
Okay.
And then you can do the transfer on death deed of the survivorship agreement. I had clients who were leaving town to go on a safari, and they had it planned for months and months, and they randomly sold their house and were closing on a new house. And literally, it was one of those things where I kept checking every day because they were leaving to go on safari, and I needed to file it because I did not want them to take this big vacation over continents and long flights and over oceans, or, potentially get eaten by an animal is what the wife always joked. Yeah, she always said, I don't want to get eaten by an animal on the safari. But that's what she was worried about. So she was like, I really want this taken care of before we go on this trip. So I kept following up with the property records every day leading up for them going, because this is key. You've got to have it filed with the property records before you pass. Otherwise, it doesn't count. Okay. Yes. So good news for her. Before she left to go on the trip, we got it filed. That's awesome. So that's the only reason I would think off the top of my head that you couldn't do it at closing.
Okay.
But I definitely like the idea of you telling your clients at closing.
Yeah.
Because it is such a great way to circumvent the probate process.
Right.
Yeah.
Well, so viewers, if you're buying, I would say, this could be on your check, just like you're going to wait to file for your homestead.
Exactly. Make this on your to-do list.
It can be, because you have to wait a little bit to file that anyways, because names have to be transferred and all that.
Yes.
The same thing.
Probably same timeline, because you've got to get everything filed with the property records. It needs to show up on the CAD, show up when you do a deed search in the property records. Yeah.
Okay.
Yeah.
Yeah.
So that's what I would recommend. Same timeline.
So usually I tell them, 6 to 8 weeks is usually kind of the general.
Yeah.
Depending on the county.
I was going to say, I do a lot of work in Collin County, not to pick on Dallas County. Dallas County usually takes a little bit longer just because it's so much bigger and there are so many people.
Yes.
So we are fortunate in Collin County. They're usually pretty good. Unless it's a holiday, I can get stuff turned around. I can get my deeds on file within 24 hours. Now, buying a house and getting the names transferred, that's a little bit trickier.
Yeah, it depends. And then, then we have all kinds of things that happen.
Yeah, it does. All right, so one thing I did want to mention too, I was talking about at tennis today. So Kim and I both played tennis this morning separately, but we both played. And I was telling my friends, I'm like, oh, I get to go be a dork and talk about deeds. I was like, because this makes me really happy. But anyway, so one of the questions that was asked, well, what happens if my house is in a trust? Yes. And so this doesn't exactly apply to if your house is in a trust, because your house is already in the trust. And so that kind of takes care of, it doesn't take care of the probate process for you, but the property's already in the trust.
Okay.
So I recommend leaving it in the trust. I mean, obviously, like I said, every case is different. if I have clients oftentimes that come from California and they have a trust and they don't really need a trust. Texas is pretty interesting because we do have so many things that allow you to make probate a lot easier. So in that regard, you may not need a trust, you might, but if it's already in there, maybe not. Again, I'm going to have to look at it. But
what about an LLC? Because I know what I've got.
Well, an LLC, the LLC actually owns the property.
Right.
And so in that case, you don't really have anything to probate because the LLC doesn't die. Right. It just transfers maybe ownership. So the LLC, even though the LLC is going to maybe be owned by a different person, the LLC is still going to have ownership over the property, unless the LLC dissolves,
that one person
when the person passes away.
Yeah.
It depends on how the operating agreement is written.
Okay.
So again, that's why these are general rules about the Texas law. And that's why I would say in general, if it's in a trust, you don't need one of these. But that I had clients that came that were here this week. They signed on Monday, and they completed all their documents, and they had a trust from Indiana. But they needed the trust there because of the probate laws and everything. They didn't need a trust in Texas.
Okay.
And I say that because in Texas, you really only need, quote, a trust if you own property outside of the state. You've got a bunch of assets that are worth a lot of money. Like right now, it's $13.6, $13.7 million each. Okay. So like, for example, if it's a married couple, that's, $27 million. Right. Not everybody has that much money. And so that's the kind of thing that you would need a trust for. But that's not to say that I don't put trust language in my wills so that they spring into being once somebody passes. Okay. So, but these clients came to me and they didn't need a trust. They only had the house in Texas. There was nothing in the trust. So their attorneys had created a trust for them and not put anything in it. Oh. Yeah. And that's why I go, what's in your trust? And they looked at me and they laughed and they said, we don't know. And I said, well, did you buy your house here in Texas and put it in the name of the trust? Well, no. And I said, well, I don't think you need it. So we dissolved that trust.
Gotcha.
So I will, so that's why it depends on a case-by-case scenario.
Right.
But typically in Texas, you don't need a trust. You just want trust verbiage in your wills to spring into being upon your death. But so that's why I say if you've already gotten a trust, you might not need it in there. You might want to leave it. Yeah. So anyway, it's just interesting because, like I said, there's so many scenarios, so many. And it depends, again, if you bought it during the community, who you want it to go to, all that kind of thing.
So I guess the summary to this is that you
need to come see me.
Yes, you need to just go see. And we've got Kayla's contact information down there for you to contact her. But if you own a property, whether you have a significant other, especially if you die.
Yeah, because you don't know who it's going to go. Right, and testate laws, yes.
And she can look at your profile, determine what scenario is going to be the best because everyone does have a case-by-case basis.
Yes, exactly.
And get you all set up.
Yeah, and one last thing to mention, in Texas, everybody's got oil money, right? You can do this with, well, not everybody, but majority of Texans have oil money. So you can do this with minerals, right? And royalty. You can do a mineral deed and a royalty deed. Yeah. So that's something to keep in mind too. So it's, like I said, it's a great way to transfer your real property to your beneficiaries and hopefully avoid the probate process, assuming that all your beneficiaries are designated.
You're basically making it easier for that.
And you're also saving money because you don't want to spend a bunch of money probating when you don't have to.
Definitely.
So,
well, this was so educational. I know that my viewers have, just learned something that they didn't know about because I did too.
Well, hopefully, and you're in the real estate business, so
we don't talk about, a lot of it's deeds
because it's riveting content.
Yes, we just don't. But it is a wealth of information, for us to all know. And if you're in, give her a call.
Sure.
Get one done.
Yeah, and let's get your estate planning work done so that you don't have to worry about it. I tell clients all the time, I do try to make it fun. I know it's a serious conversation, but I try to make it as lighthearted as possible, talking about your demise.
Yes.
So I at least, you can rest easy knowing that your family's taken care of. That's how I look at it. So
definitely.
Yeah. All right.
Well, cheers
to deeds. Yeah. All right.
Thanks for tuning in. Be sure to subscribe to the podcast on Apple and Spotify, as well as Kimberly's YouTube channel. If you'd like to contact Kimberly directly, you can email her at kimberlywoodard@ebby.com or call 214-632-2092. We hope you enjoyed our guest this week, and remember, Don't just love your home, love your community.